Start. As observed earlier by this court that the trial court findings are correct in view of the fact that the plaintiff has chosen to file the suit after almost 2 years without producing any documentary evidence with regard to exchange of communication between the plaintiff and the defendant, that she is always ready and willing to get a sale deed executed in her favor by paying the balance sale consideration. The trial court has rightly not granted the relief of specific performance in favor of the plaintiff. The relief of specific performance is a discretionary relief prior to the amendment of the Specific Relief Act 1963. Admittedly, the subject agreement of sale is dated 26/11/2009 in bracket Exhibit A1, which is prior to the amendment of the Specific Relief Act 1963. Section 20 of the Specific Relief Act 1963 makes it clear that the relief of specific performance is a discretionary relief, but the discretion exercised by the court should not be arbitrary but sound and reasonable and guided by judicial principles. The trial court has rejected the relief of specific performance sought for by the plaintiff only by giving sound and justifiable reasons as narrated supra. Therefore, this court is of the considered view that the discretion exercised by the trial court in not granting the relief of specific performance cannot be interfered with by this court. The lower appellate court erroneously and by total non-application of mind to the reasons given by the trial court for not granting the relief of specific performance has reversed the findings of the trial court by stating the reasons stated supra and has interfered with the discretion exercised by the trial court without any basis when it is very clear that the plaintiff did not approach the defendant immediately after the end of the 3-month period or before as stipulated under the agreement of sale for getting the sale executed in her favor by paying the balance sale consideration of rupees 1,10,000. The only written communication between the plaintiff and the defendant subsequent to the agreement of sale in bracket Exhibit A1 dated 26/11/2009 is the legal notice sent by the plaintiff through her lawyer dated 7/12/2011, that is after a lapse of more than 2 years from the date of the agreement of sale dated 26/11/2009. The agreement also did not stipulate that the property will have to be measured by the defendant once again after the date of the agreement of sale. When the agreement clearly mentions the extent of the property as 14 cents and there are no further conditions stipulated therein with regard to the actual measurement, the plaintiff cannot now contend that the actual measurement is only 35 coolies and not 42 coolies in bracket 14 cents, which is mentioned in the schedule to the agreement of sale in bracket Exhibit A1. The lower appellate court ought not to have interfered with the discretion exercised by the trial court in refusing specific performance by giving sound and justifiable reasons and guided by judicial principles as required under Section 20 of the Specific Relief Act 1963. Therefore, the judgment of the lower appellate court granting the relief of specific performance has to be set aside by this court as the same is arbitrary and is not guided by judicial principles, and the reasons given for reversing the findings of the trial court are not sound and justifiable. The learned counsel appearing for the appellant relied upon the following authorities in respect of his contention that the plaintiff is not entitled for relief of specific performance. Judgment of the learned single judge of this court in the case of Soundararajan versus Vittobai in bracket deceased and others in bracket 2017 4 CTC 225. Judgment of the learned single judge of this court in the case of S.A. Godandaraman versus Crystal Residency India Private Limited in bracket 2017 4 CTC 313. Judgment of the division bench of this court in the case of G. Bhanumitra and another versus D. Santakumar in bracket 2023 1 MLJ 401. Judgment of the Honorable Supreme Court in the case of Katta Sujata Reddy and another versus Siddham Setti Infra Projects Private Limited and another in bracket 2023 1 MWN in bracket civil 65. Judgment of the learned single judge of this court in the case of T. Palanisamy versus M. Varadarajan in bracket 2022 2 LW 57. Judgment of the Honorable Supreme Court in the case of K. Karuppuraj versus M. Ganesan in bracket 2021 8 MLJ 505 SC. Judgment of the division bench of this court in the case of T. R. Murugesan versus S. Balakrishnan and others in bracket 2018 3 MWN in bracket civil 270. Relying upon the aforesaid decisions, the learned counsel appearing for the appellant would submit that since time is essence of the contract as per the agreement of sale in bracket exhibit A1, the plaintiff having failed to complete the sale within a period of 3 months from the date of agreement is not entitled for relief of specific performance. On the other hand, the learned counsel appearing for the respondent relied upon the following authorities in support of his submission that the time is not essence of contract when the defendant has not fulfilled her part